Hello and welcome to the channel. If you're planning to make the UK your permanent home, then applying for indefinite leave to remain, or ILR, is likely the most important step in your immigration journey. You've spent years building a life here, working, studying, and putting down roots. The last thing you want is for your dream to be shattered by a refusal. The reality is, the Home Office can and does refuse thousands of applications every year. And in 2025, with immigration rules constantly evolving, being fully informed isn't just an advantage, it's a necessity. Today we're going to break down the 5 critical ILR bans and refusal grounds that everyone must know in 2025. Some of these are long-standing rules that continue to catch people out, while others are part of significant proposed changes that could reshape the path to settlement entirely. Getting this wrong can mean more than just a rejected application. It can impact your legal status, lead to a re-entry ban, and force you to leave the country. So, grab a notepad and let's dive into the essential information that will help you secure your future in the UK. Ban number 1. The criminality ban, when your past comes back to haunt you first on our list, is perhaps the most severe and non-negotiable reason for an ILR refusal: the criminality grounds. The Home Office is extremely clear on this. It expects applicants for settlement to be of good character. A criminal record can completely derail your application, and the rules are very specific about what constitutes a mandatory refusal. The Home Office doesn't just look at whether you've been to prison, it considers the length of the sentence you were given. These rules are laid out in Part 9 of the Immigration Rules, often referred to as the general grounds for refusal. Let's break down the sentencing thresholds, because this is where the details really matter. A prison sentence of 4 years or more. If you have ever been sentenced to imprisonment for 4 years or longer, your ILR application will be refused. This is a lifetime ban. It doesn't matter how much time has passed since the offence. A prison sentence of 12 months to 4 years. If you've received a custodial sentence of at least 12 months but less than 4 years, your application will be refused unless a period of 15 years has passed since the end of your sentence. So, if you were released from prison in 2010, you wouldn't be able to successfully apply for ILR on these grounds until 2025. A prison sentence of less than 12 months. For sentences under a year, you must wait at least 7 years after the end of your sentence before applying. Non-custodial sentences and out-of-court disposals. This is a crucial one that many people overlook. If you have been convicted of an offence or admitted to one for which you received a non-custodial sentence like a fine or a community order within the 24 months leading up to your application date, your ILR will be refused. It's also important to know that being a persistent offender, even with minor offences, can lead to a discretionary refusal based on your character and conduct. The Home Office sees a pattern of offending as showing a particular disregard for the law. Ban number 2, the deception ban: lies, mistakes, and tax discrepancies. This brings us to our second point, which is one of the most common pitfalls for even the most well-intentioned applicants: deception and false representations. This isn't just about telling outright lies on your application, it can be much more subtle. Under the immigration rules, your application can be refused if you submit false information or documents, or if you fail to disclose relevant facts. Crucially, this can lead to a refusal whether you knew the information was false or not. For example, if an agent provides a counterfeit document on your behalf without your knowledge, your application can still be rejected. Making a mistake on your form can be disastrous if it's interpreted as an attempt to mislead. While the Home Office guidance does say that genuine innocent mistakes, like a typo and a postcode, shouldn't be grounds for a deception refusal, a mistake that is material to the application's success certainly can be. But here's the area that has become a major focus for the Home Office in recent years: tax discrepancies. UK Visas and Immigration UCVI and His Majesty's Revenue and Customs HMRC actively share data. If the income you declare on your ILR application to meet a financial requirement doesn't match the income you've declared to HMRC for tax purposes, this will be flagged as a discrepancy. Let's say you're on a skilled worker visa and need to show you earn a certain salary for your ILR. If you tell the Home Office you earn £35,000 but your tax records show you only declared £25,000 for that period, this will almost certainly lead to a refusal. It can be seen as an attempt to deceive both the Home Office and the taxman, which raises serious questions about your conduct and character. Even if you have since resolved the issue with HMRC, the Home Office may still use the past discrepancy as grounds for refusal. Knowingly having unpaid taxes is an automatic ground for refusal. Ban number 3. The immigration law breach ban overstaying and breaking conditions. The third major ban relates to your own immigration history. To grant you permanent residence, the Home Office needs to see that you have respected the UK's immigration laws throughout your time here. Any previous breach can be used as a reason to refuse your ILR. The most common breach is overstaying. This is when you remain in the UK after your visa has expired. Even a short period of overstay can jeopardise your application. While there are some very limited exceptions, as a general rule, you must have had continuous, lawful residence in the UK for your qualifying. Overstaying can lead to what's known as a re-entry ban, and it would almost certainly cause issues for your ILR application. The Home Office may view it as a deliberate attempt to frustrate the intentions of the immigration rules. But it's not just about overstaying. Breaching the conditions of your visa is another serious issue. This could include working more hours than your student visa allows, working in a job that is not permitted by your visa type, claiming public funds when your visa explicitly forbids it, failing to work in your sponsored job under a skilled worker visa, which is a specific reason for ILR refusal. Any of these breaches can be used to refuse your application on the grounds that you have not complied with the terms of your leave. A poor immigration history, especially one that shows a failure to cooperate with authorities, can be seen as an aggravating circumstance that justifies a refusal. Ban number 4, the absence ban breaking your continuous residence host. This is a technical but absolutely critical rule that catches out a surprising number of applicants. To qualify for ILR, most routes require you to have a continuous qualifying period of residence in the UK, which is typically 5 years. The key word here is continuous. The Home Office has a very specific definition of what breaks this continuity. For most work and family visa routes leading to settlements, you cannot have been absent from the UK for more than 180 days in any consecutive 12-month period within your qualifying period. Let's be clear about how this is calculated. It's not a fixed calendar year from January to December. It's a rolling 12-month period. The Home Office will look back from the date of your application and check any 12-month window within your 5-year qualifying period. If your absences exceed 180 days in any of those windows, your continuous residence is broken and your application will be refused. There are very few exceptions to this rule. While some flexibility may be shown for serious reasons like medical emergencies or work-related travel that is an essential part of your job, these exemptions are not guaranteed and require extensive evidence. This rule is applied strictly. It doesn't matter if you were away for a family wedding, an extended holiday, or caring for a sick relative. If you cross that 180-day threshold, you will likely have to reset the clock and start your qualifying period all over again. Ban number 5, the big shake-up, the proposed 10-year path to ILR. Our final point is the one that could represent the single biggest change to UK settlement in a generation. In May 2025, the government published a policy document, a white paper, outlining its future plans for the immigration system. While it's crucial to state that these proposals are not yet law, they signal a clear direction of travel and are something everyone planning for ILR must be aware of. The headline proposal is to increase the standard qualifying period for indefinite leave to remain from 5 years to 10 years for most work and other long-stay visa category. If this becomes law, it would mean that individuals on routes like the skilled worker visa would need to live in the UK for a decade before being eligible to apply for permanent residence, effectively doubling the current wait time. This is a fundamental shift designed to make settlement a more demanding and merit-based process. The white paper suggests that family visa routes may not be affected by this extension, but for many others, this would be a game changer. It would also, by extension, lengthen the time it takes to become a British citizen, as you can generally only apply for citizenship after holding ILR for at least 1 year. The government has suggested there might be exceptions or a points-based system to earn settlement faster, rewarding contributions through higher salaries, professional qualifications, or working in shortage occupations. However, the details of how this would work are still unclear. So there you have it, 5 of the most critical ILR bans and refusal grounds you need to be aware of in 2025. From strict criminality rules and the dangers of deception to technical requirements like the 180-day absence rule and the massive proposed changes to the settlement timeline, navigating the path to indefinite leave to remain is more complex than ever. A simple mistake or a misunderstanding of the rules can have devastating consequences. The application fee is high and you won't get a refund if you're refused. Our goal today was to empower you with knowledge. By understanding these common grounds for refusal, you can proactively check your own circumstances, gather the right evidence, and avoid these pitfalls. If you found this video helpful, please give it a thumbs up, subscribe to the channel, and hit the notification bell so you don't miss our future updates on UK immigration. And if you have any questions or experiences to share, please leave them in the comments below. Thank you for watching, and we wish you the very best of luck on your journey to making the UK your permanent home.